Yes.
My Lord,
Huh?
may I seek indulgence to mention unlisted item number FAO number 11 of 2025, and II case number is 222 of 2025.
What's the urgency?
For the because the next court that is the land executing court had issued possession order, and the next court that is Monday. I may this matter be taken up after the daily cost list.
Let's see. Okay.
Mr. Vice.
Also, your lordship, indulgence in respect of item number 7 of hearing list, my lord. If this may be taken up after vacation, my lord.
Okay.
I have
You've
taken the
taken
consent of the other
Okay.
parties.
Mr. Victor L. Ralte, Learned Counsel for the petitioner, has prayed for adjournment of the matter with the consent from the other side. In view of the above, list after the ensuing vacation. Yes.
Similar prayer in respect of item number 10.
10. Okay. You are for the appellant.
Yes, my lord.
Yes.
My lords, if I may mention part 2, item 1. Fixed item, my lords.
Yes.
My lords,
After the vacation?
immediately on ensuing.
Immediately. Okay. Mr. Jordan Rohingthanga, Learned Counsel for the petitioner, has prayed for adjournment of the matter with the consent from the other side. Okay. In view of the above, list the matter immediately after the ensuing vacation.
Great.
Yes.
For motion, item number 1.
My lord, in the present matter, I had filed my rejoinder affidavit clarifying that the complaint was made in respect of land dispute.
Why have you filed a rejoinder affidavit? This is in motion stage.
Yes.
So we have
earlier-
not even issued notice.
Not yet. Notice was not yet issued.
Then
In
why
the-
have you filed a rejoinder?
My lord, in the last court date, I had made my request to submit my rejoinder affidavit, clarifying that the complaint was filed in respect of land dispute at Champai. By filing
No.
this,
I don't understand. What rejoinder? Rejoinder to what?
rejoinder regarding the complaint,
You file it in a form of an affidavit, this thing, in your petition. What rejoinder? This is the motion stage. Why have you
Yes.
filed a rejoinder?
my lord, here earlier, the matter was listed. And when the matter was listed, the situation about how the dispute started was not properly supported with the supporting documents.
So file additional affidavit, not rejoinder. Rejoinder is your reply to the counter affidavit filed, isn't it? So if you want all that, file your this thing, additional affidavit.
My lord, here the matter pertains to a request, appropriate direction in favor of the petitioner, directing the Land Revenue and Settlement Department to decide dispute. Look, in respect of a particular land at Champai district.
The husband
Here-
again submitted the same petition against. Where is the other case? No, this cannot be a rejoinder. You file an additional affidavit. Now first you have filed a writ petition.
Yes,
Okay, which is
yes.
still at its motion stage. We have not
Yes.
even discussed.
Yes.
Now, in this writ petition, if you want to add something more to your writ petition at the motion stage, you file an additional affidavit supplementing your previous writ petition.
Yes.
Yes, what? What is this rejoinder? Rejoinder to what? In reply to what? Where's the counter affidavit file? There's no counter yet. Notice has not been issued yet.
My lord, yes. That I'll do.
Rejoinder to what? Why you filed a
That I'll
rejoinder?
do. I'll submit the additional affidavit.
Additional affidavit, isn't it? Not a rejoinder. Rejoinder is in reply to the counter affidavit filed by the this thing, respondents, but no notice has been issued, no counter where you have to file a rejoinder. Isn't it?
My lord.
Yes. Heard Mr. F. Engliana, learned counsel for the petitioner, who submits that he may be allowed to file an additional affidavit to the instant writ petition. In view of the above, list the matter. When do you want it? After
After
the vacation? After
lord.
the vacations. Yes, notice not issued, this thing yet. After that, with the additional and the present, this thing, writ petition, we will issue notice
My lord.
together in one.
My lord.
Item number 2.
May I please your lordship? My lord, the petitioner herein is a lab technician, initially appointed in the year 2001 on co-terminus basis, and thereafter he was absorbed and regularized into government service on 2010. And thereafter he was also confirmed by the respondent authority, and he has been enjoying all the benefits, entitlements of regular government employee for several years. He had already enjoyed the first financial upgradation under the MSCPS, my lord. And now he, being the senior most, is now due for promotion to the post of senior lab technician. But lately, my lord, the respondent authority had came up with a decision that there are several employees under the Health and Family Welfare Department with having unauthorized appointment of the initial appointments. And as a result, my lord, I am impugning the letter dated 19/2/2025, page number 71, whereby the respondent authority had directed to redraw the interstate seniority list of Group B, C, and D staff, my lord. This decision was made after 25 years of the petitioner rendered his service
It's
as a good
15
employee.
years, not 25.
His entitlement starts from 2001, my
Has
lord,
already rendered 15 years of regular service.
regular service.
Huh.
So now, my lord, I was debarred the future financial upgradation as well as the promotion at this stage, my lord, which is impermissible in law. Now, it is a settled law that, my lord, this is not illegal appointment. Even if this is irregular appointment, my lord, they were regularized, and moreover, when they were confirmed, those irregular action of the state respondents were regularized by the confirmation, my lord. At this stage, the state respondents have not made any concrete order, but I was debarred from getting any financial upgradation or promotion to the next step.
So now you were also due for second financial upgradation,
Yes, my lord.
isn't
Yes,
it?
my lord.
So did you get this thing upgradation?
The first one I have already got it with effect from
He is also
2011.
now due for second. So you are due for the second, which
Yes,
has
my
not
lord.
been granted to you. Is it?
Yes, my lord.
Okay. You will issue notice. Let's see. Heard Mr. Victor L. Ralte, learned counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India, challenging the legality of the letter dated 19/02/2025, which had directed the department to redraw the inter-C seniority list of Group B, C, and D. Full stop. The learned counsel submitted that the case of the petitioner was that he was initially appointed as the laboratory technician by office order dated 11/10/2001 under the NIDDCP within brackets CSS close bracket on coterminous basis, and was regularized on 26/02/2010
Then,
with effect from 01/02/2010 and confirmed on 22/02/2017 with effect from 01/02/2017 2017. Full stop. The petitioner was also granted the first financial upgradation in terms of the MACPS 2010 with effect from 11/10/2011. Full stop. The petitioner considered himself to be the senior most amongst the lab technicians and eligible for promotion to senior lab technician in terms of the recruitment rules of 2018. Full stop. The Learned Counsel also submitted that the petitioner is now due for the second financial upgradation with effect from 12/10/2021. Full stop. However, while the petitioner was expecting his upgradation and promotion, the impugned order was made by the respondents after the petitioner had already rendered 15 years of regular service, and hence the writ petition. Then you issue a notice of motion to the respondents. Ms. Vani Siami, Learned Government Advocate, accepts notice on behalf of the state respondents. Anyone else? No.
All state.
Respond. No need to issue formal notice. Requisite copies of the writ petition to be duly furnished to the Learned Government Advocate. List after 4 weeks.
Yes, my lord. My lord, at this stage, this impugned order has not been implemented by the state respondents if some protection may be given. Direction was to withdraw interstate seniority in respect of Group B, C, and D. I belong to Group B. And in the last final seniority list, I am the senior most, which was issued on 2020.
No. But when the list comes out, you could always still be the senior most.
My lord, what I mean to say is that this has not been yet implemented by the state respondents. They have not made the withdrawal interstate seniority list in terms of this impugned order as of now. So if some protection may be given, not to a opponent in terms of the impugned order, pendency of the standard petition, my lord.
No, but see, when this order is implemented, let's see the order.
Page number 71, my lord.
It's not necessary that you would be placed in the last list also, isn't it? Reconsideration, but you have some apprehension. So you're saying this is concerning unauthorized appointments.
That is the allegation, my lord. And that
But
was not,
then, since if you say that yours is the same, yours is an authorized appointment, they're going to just have a look again, isn't it? They're just going to investigate at this stage.
Yes, Your Lordship. And if the list come out also, Your Lordship, regarding to this writ
Once the list
petition,
comes,
that can
then
be changed
maybe
at
we
any
will have a
time.
look. It's not as if you are placed last, but you have some apprehension, so let's see.
my humble submission is that if status quo may maintain as of now,
Let them investigate. Investigation has to be done, unauthorized this thing, appointments or not, isn't it? So, in fact, it appears that the writ petition is slightly premature, but let's see. Let them see, isn't it?
Obliged.
For admission, item number 3.
Your Ladyship, I am appearing on behalf of the Senior Counsel, Mr. Sila Ramzawa. If additional time could be granted to file the rejoinder affidavit. Your
Yeah.
Ladyship, there is an information sought through RTI, which is crucial for preparing the rejoinder, and it has not been provided yet. And so the RTI appeal is also being recently filed. So if your lordship could grant us additional time.
See here, the last court's order was that final chance.
Yes, your ladyship. However, the RTI, which is crucial for preparing the rejoinder, has
We
not
should
been
have pursued
provided.
the matter before. Anyways, we will give you a chance to file a rejoinder affidavit because rejoinder affidavit is based on the counter affidavit already filed, isn't
Yes,
it?
your ladyship.
Subject to you paying a cost of how much? 5,000. I think you can afford that. You cannot keep, isn't it? Yes, Miss
Emira Elmar.
Emila so and so, learned counsel for the petitioner is present along with Mr.
Lobo Maralte,
Roku Maralte,
on behalf
learned
of my senior Mr.
appearing on behalf of his senior Mr.
Bilal Ramena.
Bilal Ramega. Roku Maralte, learned counsel, appearing on behalf of his senior Bilal Ramega. Full stop. The learned counsel for the petitioner has prayed for further time to file the what's his rejoinder affidavit. Full stop. It is seen in para. It is, however, seen that this court, in its previous order dated 07/11/2025, had noted that last chance is provided to the petitioner to file counter affidavit, failing which the matter would be decided without the rejoinder affidavit. From last chance, make it in italics. Okay? Rejoinder full stop. In view of the above, in view of the above, the learned counsel for the petitioner submits that the delay in filing the rejoinder affidavit is due to the fact that they had asked for some information through RTI, which they wanted to incorporate in the rejoinder affidavit. In view of the above, this court, on considering the observation made by this court on 07/11/2025, find that it would be in the interest of justice if a rejoinder affidavit is allowed to be filed by the petitioner, however, it should be subject to the payment of a cost of rupees 5,000. Stop. Accordingly, this is the matter after the yes, vacation. Is there any urgency? You're this thing? No. You're the petitioner. In view of the above, list the matter immediately after the ensuing vacation. Yes.
Highly obliged.
So you pay a cost, then you can file.
Your ladyship.
Item number 4.
Okay, and then the cost will be given to the state legal services. Yes.
Lord, leading counsel couldn't appear today due to some personal difficulty.
Who did not appear?
Leading counsel, Mr.
Who is the leading counsel?
Jonathan Larinconga.
Okay. Who's for the respondent?
My lord, none has.
Private
no-
respondent or
yes,
who?
yes, private respondent, sole
Oh
respondent.
no, notice has not been issued till date.
Yes,
This is the
RFA.
admission state RFA.
Yes.
So what is the case about? We are going to, do you know what the appeal is about?
Yes, it's regarding to set aside the impugned judgment order passed by the additional district judge regarding guardianship certificate.
So who was regarding guardian? Who was given the guardian? Made the guardian of the minor?
The instant respondent,
Who's the respondent? Father or mother?
father of the minor.
Okay, so guardianship certificate was given to the father,
Yes.
and now you are the mother, biological mother.
Yes.
Did you get the chance to file your written statement or give your evidence
No, my lord.
before the trial
It was
court?
passed ex parte.
Okay. Okay, will this thing, will issue notice? You
Yes.
don't have to wait for your senior. Your name is there in the cause list,
Yes,
isn't
my
it?
lord.
Huh? Mr. Ram Murmu, learned counsel for the appellant is present and submits that the instant regular first appeal is filed against the judgment of the learned additional district judge, comma, Aizawl district, instead of against the order dated 31/01/2024, passed by the then additional district judge, okay, Aizawl district, in guardianship application number 128 of 2023. Full stop. The learned counsel for the appellant submits that the appeal against the guardianship's application number 128 of 2023 is preferred by the appellant, since the guardian of the minor son, name of the son,
Yes, George Ramthanpuya.
namely George Ramthanpuya,
Yes.
has been granted to the respondent, father of the minor son, while the appellant is the mother, biological mother of the minor son, and the guardianship certificate was granted ex parte without the appellant being given a chance to object to the said guardianship certificate. Full stop. On hearing the submissions made by the learned counsel for the appellant, this court find it appropriate to admit the appeal. Notice be issued to the sole respondent through registered post with AD within 3 working days, returnable by 4 weeks. Okay, list after 4 weeks. Most probably after the vacation, 4
Yes.
weeks. Isn't it?
Yes.
How many more weeks? Let's see, 1, 2, huh? Yes.
Item number 5.
My lord, as per the order dated 23rd 9/2025, my lord, I have filed the Talabana along with the copy of RFA
Okay.
for service of notice, and AD card has also returned from the respondent regarding the service of notice, my lord.
You have filed what?
Talabana, my lord.
Okay, no, that, okay.
everything
So,
is done, my
AD card returned.
Yes, my lord.
Let's see the office order. Possession. Okay, then we'll wait for the respondent to be represented. Let's see the correspondence file. Is it duly signed? There's a signature, 1010. Okay. Yes. Mr.
J.H. Ricky, Lord.
Yes, J.H. Ricky Lalrotfella, learned counsel for the appellant is present and submits that as per the office note dated 27/10/2025, AD card is returned after notice being duly served to the sole respondent. Full stop. This court, on perusal of the AD card finds that notice was duly served to the sole respondent on 10/10/2025. Full stop. Notice is deemed complete upon the sole respondent. Full stop. However, none appeared for the respondent. In view of the above, this court find it fit to give a chance for the sole respondent to be duly represented. List the matter again after 4 weeks.
Obliged, my lord.
For orders, item number 6.
Yes.
My lord, if permit, may I allow to be withdrawn with liberty to fair press because the solicitor have an interest arising out of the LA draft award 1 of 2012 will be approached for review and the
Wait,
rest
I don't understand. What do you want?
withdrawn with liberty to
Okay,
fair press.
liberty to withdraw and file afresh. Okay. What is the IA about?
This IA is about the substitution.
Substitution application.
Yes, in the last court that the order stated that to
Okay, so the substitution application will be drawn. Okay. So supposing
along with the main.
with the main writ petition.
Yes.
Because I think it's the grandmother who died. Is it?
No,
This is a different case.
husband, yes, the husband died and the wife had filed this instant
Okay,
petition
okay,
on
fine,
the
fine. No, I'm confusing your case with some other case. Anyways, heard Miss Jacinta so-and-so, learned counsel for the petitioner who has prayed for withdrawal of the instant writ petition with a permission to file afresh. Miss Mary L. Kyangte, learned government advocate, is present along with Mrs. Zairam Sampui, line CGC for the Union of India. So, the learned counsels for the respondents have not raised any objection to the prayer made by the learned counsel for the petitioner. In view of the above, the instant writ petition, along with the connected IA, within bracket C 97/2025, stands disposed of on withdrawal with a permission to file afresh if so advised. Yes.
much obliged.
Item number 7.
Lordship, I'm appearing on behalf of my senior, and with regards to the IA, the ID card is not returned till today, my lord.
Okay, so we have to wait for return of service of notice upon 1, 2, and 3, isn't it?
Yes, my lord.
Mr.
Lalmang Isama.
Lalpanga Isanga. Is your name there in the cause list?
No, my lord.
Appearing on behalf of, appears on behalf of his senior, Mr.
Johnny L. Towson.
Johnny L. Tauchong. Full stop. It is seen that return of service of notice upon respondents number 1, 2, and 3 is still awaited. In view of the above, this is the matter after the ensuing vacations.
Much obliged.
Item number 8 and 9.
Yes.
May it please your lordship. My lord, as per the office note, AD card is yet to return in respect of respondent number 2, owner of the vehicle.
So, where's he? What's his address?
Tenzol, your lordship.
Can you, this thing serve notice through Dusty?
It might be difficult. Tenzol is.
You want to issue fresh notice? How long have we been waiting for the return?
Since October, I believe.
October. You can take steps for issuance of fresh notice. at least.
I apologize, your lordship. We had taken steps on July.
July, long time back.
Long time back. 16/7/2025, we had taken steps.
So you take fresh steps because the owner is necessary, isn't it here?
To be
Because
very
you're
honest,
saying
Your
that
Lordship,
you're not the one to pay, it's the
no,
owner.
no, Your
Is
Lordship,
it?
we are challenging the quantum.
Quantum.
We're not denying
Quantum
the
only,
insurance
Oh,
policy as
quantum,
such.
then the same, is the owner required?
No,
Not entirely, Your Lordship.
the insurance policy is valid, my lord, so far as knowledge is
We are on the calculation.
It's just a calculation, then owner is not, if the insurance is liable to pay, then owner is not required, is it?
Yes.
You can pray for striking of his name. What is the IA for?
I is for condonation of
many days?
189.
So written objection filed? No,
I have.
filed.
Copy was just handed over to me just
Okay.
now.
Then in the next date, we can see.
My lord.
And in the meantime, by the next date, if this thing, notice cannot be served to the respondent number 2, you can pray for striking of his name. Isn't it? Yes. Heard Mr. Halal Fakoma, learned counsel for the applicant, who submits that notice upon respondent number 2 is not complete till date. Full stop. He further submitted that though the learned counsel for the opposite party, respondent number 1, has filed their written objection, a copy was furnished to him only today. In view of the above, matter be listed after the ensuing vacations.
My lord.
Okay. While wherein if notice, if service of notice upon respondent number 2 is not complete, the prayer for condonation of delay may be considered in his absence.
My lord, regarding the cross objection, item number
Oh,
9.
there's also
is it-
cross objection.
Yeah. Yes, my lord.
So, the cross objection
For the first
will be
time,
considered.
the cross examination is put up, my lord.
Cross-examination.
Cross-objection.
No,
Cross-objection, my lord.
cross-objection. Cross-objection. Where's the IA? Oh, here. Heard Mr. L.H. Lianshima, learned senior counsel for the applicant, who has filed, assisted by Ms. So-and-so, learned counsel, who has filed the cross-objection to the connected MAC appeal number 12 of 2025. So, copy of the 2025 full stop. The cross objection is filed regarding the quantum
Yes, my lord.
of the award.
My lord, the wrong multiplier has been
Okay,
applied by
regarding the
the
quantum, regarding the quantum of the
Right, madam.
award made by the learned tribunal in MAC case number 38/2020, dated 27/09/2024, wherein the learned counsel submits that the multiplier applied by the learned tribunal is not the correct multiplier to be applied. Stop. Copy of the cross objection to be duly furnished to the learned counsel for the
Insurance.
appellant / insurance company. The cross objection will be considered along with the main MAC appeal. Yes.
lord.
And is accordingly to be listed. Full stop. So now it's the IA. No. Cross objection not now. IA will be considered first.
My lord.
So cancel that. Cross objection after this thing, disposal of the IA. Okay, so cross objection, just leave it. Because without the IA, if you cannot file a cross objection.
The appeal has to be admitted, I think.
If delay is not condoned, then there is no.
So nothing. So regarding the cross objection, just cancel. Let it just be
My
there.
lord, my lord.
Isn't it?
There is-
Yes.
Supplementary cost list, item number 10.
Oh, this is the IA for condonation of delay. Is it? No, what is it? Oh, you're this thing, yes.
This is
The
the
IA is for what?
is regarding the stay order, file under section
IA is for stay.
stay order.
So we have to
file
look
under
at the
section-
FAO first, huh?
My lord, the brief facts of the case is briefly I'll say it. Then 12/9/2022, civil suit number 45 of 2014 was disposed. It is in page 11. It is in page 11. Then this is the order. In this order, the respondent in this the respondent here
This is an FAO. So this is a civil suit and a judgment order has already been made. So you have to appeal against the judgment and order also, isn't it? So what is the FAO? Against which order?
FAO is against the possession order because the partial payment was already paid.
Wait. So in the you're not appealing against the judgment.
Judgment and order is not appealed.
Okay, what is the this thing, operative part of the judgment? Let's see.
Operative part of the judgment is in page number 25.
The decree.
Decree, yes, my lord. Then in this decree, it is mentioned that the landed property covered under ISO 205 of 1987 located at Charles Lembea was declared as the rightful owner.
Plaintiff is the rightful owner, yes.
This plaintiff is the respondent herein, and
further order
that defendant shall hand over the suit land for peaceful possession of the plaintiff within 3 months of of this order.
Yes,
And this is the case. And thereafter that the respondent herein had filed the execution case.
Okay.
And during the pendency, both parties had come to the compromise agreement. It is in page 27. 27 is the Mizo vernacular, and 27A is the English vernacular.
No.
And in this compromise settlement, in lieu of that,
where's
it
the
is in
compromise?
page 27. That is Mizo vernacular, and 27A is the English vernacular translation. And in this agreement is that in lieu of LSC, the appellant herein had paid 50 lakhs to the respondent herein. And thereafter that, the payment was met. Payment was met in 2 days. Then that is happened on 27 November 2024, 10,000 out of 50 lakhs. 10 lakhs out of 50 lakhs. And it is in page 29, my lord. Payment was met 10 lakhs on 19/3/2025 out of 50 lakhs. Then thereafter that, my client has faced a personal problem like her husband was died.
So no, how
Then
much were you supposed to pay?
her
How
husband
much
was
were
dead.
you to pay? How much
30 lakhs.
you're supposed to pay? 50 lakhs, isn't it?
Yes,
Out of 50 lakhs, you have paid how much?
20 lakhs.
20, 30 is remaining.
30 is remaining. Then 30 is remaining, and thereafter that we are facing a personal problem like my husband died and all that. Then because of that we are a little bit difficult to make payment continuously. Then because of that, the respondent herein had filed another execution case number 209 of 2025. Then when they
Where's that page?
it is in page 38. That is the order
38.
sheet. Yeah, 38 is the first order sheet. And the application is in page 32.
So page 38, wait, favor and so much is discussed for, no, then judgment or debtor is to make a payment of at least rupees 15 lakhs to the judgment debtor on 30/10/2025. Then what happened? This is an order to-
this is the case, but the executing court did not give me any opportunity of being heard. We want to submit something, but
No, but see, this is an order sheet, okay?
this is an order sheet. Yes, I know, my lord.
Okay. So it's directed to make, the lakhs to then is directed to make payment of on 30. 30 is already gone, October.
13 is already gone. On 30th,
What happened on 30?
lock and key. Order was directed to lock and key of my
Where's
house.
the order?
It is in Roman number 4 of my petition.
Where Roman number 4?
It is below the index. Below the index. Roman number 4.
Okay, so execution 209.
Yes, my lord.
Is it?
Yes, my lord.
Read 5, page 5.
Page 5. This is an execution case number 209 of 2025 submitted by the decree holder against judgment debtor for executing the decree dated 12/9/2022 in civil suit number 45 of 2014. Learned counsel are present. Learned counsel for the decree holder submit that the judgment debtor has not made up any payment as directed in the last court date. Therefore, the officer in charge, Bongkong PS Aizol, is directed to put the residential building of the judgment debtor located at Jalprang Selembang under lock and key and submit its report on or before 21/11/2025. This is the order and the executing and the.
So is this the house you're residing or some other house?
This is our house which we are residing. It is under lock and key, and thereafter that the court had ordered that to possess my residential building. Because of then we are intended to continue the amount which we are come to the.
But you have to do it fast. When will you be able to pay?
My lord, we need little bit some time.
Okay. Anyways, I heard Miss Jacinta so-and-so, learned counsel for the appellant, who has filed the instant FAO under order this is 41, is it?
45 of 2014, the civil suit number.
No, under order 41, read with section 96, is it?
Sorry, my lord. Yes, 41, read with section 96.
Under read with section 96 of the civil procedure, you have to see whether the this thing is appropriate or not, the section, the order. With section 90, under read with section 96 of the Civil Procedure Code and section 17 within brackets 2 of the Mizoram Civil Codes Act, 2005, praying for setting aside the impugned order dated, make it only one, not the two, not the order sheet, okay? 30/10 is what?
3010 is the lock and key. Order for lock and key of my residence.
The one which you showed me.
Yes.
Where's the other one then?
The other one is in Roman number 1 and Roman number 2
Show me the
and 3.
What you showed me was only
Look and key.
2111. Where is the 30, the other one? The other,
The other
order?
one is in Roman number 4, 4 of 5.
Okay, impugned order dated, make it the first one, dated 30/10/2025 and 21/11/2025 in execution case number 209 of 2025, wherein the learned trial court had held that, ordered that the officer in charge, Bonk on PS Aizol, was to put the residential building of the appellant slash judgment debtor in execution case number 29 of 2025, comma, under lock and key and that the judgment debtor and her family who were still residing within the residential building were direct to immediately vacate the residential building and give possession of the site to the decree holder. Full stop. The learned counsel submits that the state impugned orders were passed without giving an opportunity of to the appellant slash judgment debtor of being heard, and submits that unless the said impugned orders are set aside, and quashed, the appellant slash judgment debtor would be facing irreparable hardship. Good stuff. She further submits that the judgment debtor and the decree holder had entered into an agreement on 25/07/2024, wherein the appellant slash judgment debtor was to pay a sum of rupees 50 lakhs to the decree holder for the residential building wherein he was resided. However, due to some personal difficulties, that is the death of her husband, he has failed to repay the balance of rupees 30 lakhs for which the impugned orders were passed. The learned counsel submits that the appellant slash judgment debtor only needed a few more days, only needed some time, okay, to pay the balance amount, and it is not the case of the judgment debtor that she is not going to pay the balance amount. Then new para. The learned counsel for the appellant / judgment debtor also submitted that unless the said impugned orders dated, those two orders, so and so, as stayed, the appellant would be suffering irreparable loss. She therefore prayed for stay of the said impugned orders till the disposal of the instant FAO. Stop. On hearing the new para, submissions made by the learned counsels, this court find it appropriate to admit the said first appeal order and to issue notice to the sole respondent through registered post with AD within 3 working days, returnable by 3 weeks. Meanwhile, on considering the submissions made by the learned counsel for the appellant, this court find it appropriate to stay the said impugned orders dated so and so till the next date of listing. List after 3 weeks. Yes. No, you have made this thing separate application in the IA, isn't
my
it?
lord.
Oh, so list after 3 weeks. I've said that, isn't it? Then full stop. Okay. Issue notice. List after 3 weeks. Then in the IA. Okay. In the IA, heard Miss Jacinta so and so, learned counsel for the applicant who has filed an application under order. Again, 41 Rule 5, read with Section 151 of the Code of Civil Procedure. Post stay. I'm just wondering the correctness of this thing. Anyway, to first stay of the operation of the impugned order dated 30/10/2025 and 21/11/2025, passed by the learned Court of Civil Judge within brackets Senior Division -3, Aizawl Judicial District in execution case number 209/2025, praying for the stay of the said orders wherein the applicant was asked to vacate her residential building and for her residential building to be put under lock and key. Full stop. The learned counsel submits that unless an interim order for staying the operation of the said orders are passed, the applicant would be suffering irreparable loss since she would be evicted from her residence, and therefore, is she staying alone?
With her daughter.
Evicted from their residence with her daughter, and they would be facing irreparable loss. Stop. Considering the nature of the submission made, this court find it appropriate to stay the operation of the impugned order dated 30/10/2025 and 21/11/2025 till the next date of listing. Full stop. Meanwhile, notice be issued to the sole respondent through registered post. Again, here with the list after 3 weeks.
That's your place.
Okay, none appeared for the counsels on call. Call the matter. So they know what.
Part 2, item number 8.
None appeared for the parties on call. List after the ensuing vacation.